This voice thread is going to finally conclude our discussion of incitement to illegal action. That said, I want to just take a moment and talk about why we are approaching this the way that we are. So free speech issues are a voluminous area of constitutional law. And so we're going to be selecting in this class what we look at, right? We're going to look in some detail at certain areas of exception, but not all of them. Well, that being the case, why are we looking in so much detail at incitement, you might ask? Well, there are a couple of reasons for this. One, it's a good introduction to the basic principles that we're going to see in the other areas of free speech jurisprudence, right? So we're going to see in the seeds, or we're going to see the seeds of all sorts of really important ideas in these cases. Second, I want to give you a sense of how the court gets where it ends up getting. Right. So as we saw with the freedom of religion cases, once a test is set, that doesn't necessarily mean that the question is settled for good. Right. So remember Sherbert versus Werner being completely sort of gutted by Employment Division versus Smith, for instance. Well, we see a lot of this movement back and forth in the incitement cases. And we also see some very clear reasoning. The incitement cases are also important on a kind of meta level because we're going to see some really kind of like heavyweight justices articulating really important ideas like what is a legitimate state purpose, right? Like what does neutrality mean? What does the state, actually want out of punishing potential criticism, and what are the dangers of that? So we're going to conclude with that today, and then I'm going to preview the next area that we're going to look at, which is fighting words. We left off in the last voice thread with the Gitlow case, which is covered in some detail in your book. We're going to pick up now with Whitney versus California, a case from 1927. So Whitney is important for a number of reasons. First of all, because we're going to start to see some merging between different First Amendment areas here, right? So when we turn to freedom of association, we're going to see very close parallels and often intersections with freedom of expression. And the reason for this is that association and expression are like inherently tied together, right? So people associate with other people for certain purposes. Often those purposes are derived from the kinds of activities that are key to the freedoms that we see in the First Amendment, right? So political activity, speech, sometimes religious activity. So it's very difficult to actually fully separate your freedom of association from your freedom of expression. And we see this here being foreshadowed as early as 1927. So Whitney versus California is another advocacy case. As you'll recall, in the decades leading up to this, the court had been kind of moving back and forth between the bad tendency test, right, which is the common law test, then kind of tightening it up and moving towards the clear and present danger test, which introduces an element of immediacy, right? The danger needs to be immediate, not just some sort of vague potential danger in the future. But then we see, again, after that, a movement back to the bad tendency test. So we left off last time, as I said, with Gitlow, which wasn't a particularly encouraging case for anyone who is a proponent of free speech, because in Gitlow, we saw the court endorsing a very low level of judicial scrutiny for cases involving advocacy of illegal action. So Whitney versus California comes along a couple of years later, and this dealt with California's Criminal Syndicalism Act being applied to a member of the Communist Labor Party of California, right? So Whitney, right, as your book notes, was an heiress of a fairly wealthy family. So she's coming into this case in a position of relative privilege. And indeed, even though she doesn't win her case, she doesn't end up serving a particularly long sentence. Would that have been the case if she didn't come from a prominent, connected family? We don't know. But ultimately, there are a couple of things working in Whitney's favor. So for one, she herself did not endorse the revolutionary doctrine that the Communist Labor Party promoted. Nonetheless, the court upheld her conviction for violating this criminal syndicalism law because of her membership in the organization and because she was aware of the platform, right? And so the platform, in this case, is the objectionable material because it was a communist party, right? So communism is built on Marxism and Leninism. Both of those, or that philosophy generally operates on a sort of like progressive view of history that argues that societies go through these inevitable historical stages that are driven and moved forward by class conflict, right? So Marxist-Leninists argue that revolution is inevitable. So that's kind of a descriptive fact. But they also argue that revolution is desirable, right? So that is more of a prescriptive feature of these philosophies. And so if you, like Ms. Whitney, joined the Communist Labor Party in the 1920s, you would belong to an organization that advocated revolution, right? That advocated class conflict. And so because Ms. Whitney was aware of this part of the organization's platform and nonetheless continued her membership, she was found guilty of violating this Criminal Syndicalism Act. So if you look at the majority opinion in Whitney, we see that Justice Sanford writes it, and he applies bad tendency logic, right? So this is similar to the logic used in Gitlow. Sanford argues that, and I quote, "By enacting the provisions of the Syndicalism Act, the state has declared through its legislative body that to knowingly be or become a member of or assist in organizing an association to advocate, teach, or aid and abet the commission of crimes or unlawful acts of force, violence, or terrorism as a means of accomplishing industrial or political changes involves such danger to the public peace and security of the state that these acts should be penalized in the exercise of its police power." He goes on to say that the act, and I quote, "may not be declared unconstitutional unless it is an arbitrary or unreasonable attempt to exercise the authority vested in the state in the public interest." That probably sounds familiar because it is very similar to the argument made in Gitlow. However, we see a little bit of a departure here. And I'll talk about that a little bit more in the next slide. So we're going to look at one of these concurrences, right? So remember, concurrences are opinions that are written by justices who voted with the majority. However, often a concurrence is written because the justice maybe disagrees with the reasoning that the majority used, although they agree with the outcome. Alternately, maybe the justice wants to add something else that they think that the majority opinion left out. Occasionally, we'll see a concurrence like the one that we're going to see here in Whitney by Brandeis. And these are concurrences, right? The word concurrence means agreement. But these are concurrences that look an awful lot like dissents, right? So the justice says, yeah, I'm going to vote with you, but ultimately I think you decided this the wrong way. And we'll see a couple of cases as we go throughout the course where this happens. And Whitney is one of them. Now, recall that Louis Brandeis is something of a kind of stealth free speech proponent, right? So remember, he often joins Holmes and Holmes's post-Abrams opinions. And there's some speculation that actually it was Brandeis who ultimately convinced Holmes to change his mind in Abrams. Regardless, we see Brandeis here kind of coming out a little bit more explicitly with his more quote unquote, sometimes people refer to this as like a libertarian approach to free speech, but we might just see this as being a sort of like broadly permissive approach to free speech. So if we look at Brandeis's now fairly famous concurrence in Whitney, we see him depicting society as being kind of full of conflict all the time, right? And needing various safety valves. So his argument ultimately is that free speech is good for everybody, right? That even speech that seems dangerous to society on its face, like for instance, what Whitney was engaged in here, which was encouraging revolution, that even that is ultimately good for society to kind of let that out in the open and let people discuss it. So he articulates a number of different justifications for broad free speech protections in his Whitney concurrence. So the first one is to obtain truth, right? So this is similar to what Holmes argued in his Abrams dissent, right? So remember, in Abrams, Holmes argues for the quote unquote marketplace of ideas, right? So Brandeis says, like, look, we want this because, we want to get closer to the truth. We're more likely to be able to do this, with more free speech, not less. And so the quotation I'm going to take from the decision that where he articulates this idea is, and I quote, "If there be time to expose through discussion the falsehood and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence." End quote. So this justification towards, moving towards the truth, there's still this kind of like context piece that we see foreshadowed, back as far as Abrams, where Brandeis acknowledges, okay, sometimes, you might have imminent danger, right? So he says, if there's time to expose through discussion the falsehood. Okay, so if it's not an emergency, he says then that the remedy for dangerous speech isn't suppression, but rather the remedy is more speech. So do you agree with Brandeis about this? Is the correct remedy to potentially dangerous speech more speech? Why might he say that? What are the dangers in suppressing speech like Whitney's, right? Speech that maybe threatens the government or argues for its overthrow. Okay, so second, Brandeis gives a completely different reason for more permissive free speech jurisprudence. And that's what we would term like quote unquote Republican virtue. So when I say Republican, I don't mean like partisan, political party Republican. I mean what's sometimes referred to as like small r, republicanism. So this is a broad political philosophy that dates all the way back to, ancient Rome, right? So like Cicero is a classical Republican. So is Machiavelli, Rousseau. So if you've taken 150, you've read probably at least some of these thinkers. But Republican theory argues that citizenship is a really important and very serious responsibility, right? And so your public life is not a trivial matter. Your public life, acting in your capacity as a citizen, is every bit as important as your private life, right? And your sort of like private pursuits, and arguably more important, right? So a classical Republican would say, you should be a citizen first and everything else second. So classical Republicans tend to put a lot of emphasis on virtue, right? And especially civic virtue. So civic virtues might be the kinds of things that we would look for in an active and responsible citizenry. Well, Brandeis turns to this old idea in his concurrence in Whitney, right? And so he argues that, a virtuous citizenry has to come face to face with these very difficult truths. And that this is going to demand a lot of us, right? So we're going to have to, again, like come face to face with these truths that maybe we don't want to acknowledge. And so we need to have certain qualities to do that responsibly. And that includes, courage, deliberation, intellectual integrity. So he thinks that the way that we cultivate these capacities in our citizens is by letting them practice those virtues. How do we let them practice those virtues? Well, by going out into a relatively free and open public sphere to debate with each other, right? So he refers to these as, and I quote, deliberative forces, right? So deliberation means talking to other people, listening to their reasons, and giving your reasons, right? And so he thinks the way to do this is to, again, kind of like lift the restrictions and trust the citizenry to be able to do this responsibly. So he argues that these responsible deliberative forces will prevail over the quote unquote arbitrary, right? So arbitrary decisions of government, as long as there's time and space for counter speech. All right, so Brandeis makes a third argument for allowing greater protections for free speech, and this is related to a second argument. So not only are there sort of broad civic benefits for the citizenry in allowing them to engage in free speech, right? So not only does it sort of on a collective level build a responsible, competent citizenry, but also there are individual benefits, right? So here he is very much drawing on the same sources as Holmes did, right? Remember Holmes's argument about the marketplace of ideas? Well, that comes directly from John Stuart Mill in On Liberty. So one of the arguments that Mill makes in On Liberty is that if we are to cultivate ourselves to become, more reasonable, sort of like more virtuous, better, more thoughtful people, then we need to have the freedom to engage in debate with others, right? So we can kind of like sharpen our devotion to our, to the ideas that we really do want to endorse. And at the same time, we can also kind of be discouraged from things that we don't necessarily want to endorse by engaging in debate with others and hearing things that we might not otherwise hear. So Brandeis argues this as well and says that free speech is important to cultivating individual happiness, individual freedom, and really like the development of your own individual faculties. All right, and then finally, Brandeis argues, again, for a sort of collective benefit. So those of you who have read a lot of like ancient political thought, and specifically if you've read Thucydides on the Peloponnesian War, this is going to sound very familiar because this is a belief that was very common in ancient, especially Greek political thought. And so the idea here is that there's always some danger of civil war, right? And so most of us probably don't think that because we live in a fairly stable state. But Brandeis points out that, you need to have some sort of safety valve. So he's operating from the premise here that there's always a certain amount of conflict that exists in any political community. And that conflict is always kind of roiling beneath the surface. So we can take a couple of different approaches to that conflict. Approach number one, which is often, the most appealing one, right? And this, in fact, is what Thucydides and Plato would endorse, is that you suppress it, right? That you kind of come down like a ton of bricks on any form of dissent. We also see this, for instance, in Hobbes, for those of you who've taken 150. Right? So you have to suppress the dissent because otherwise it will spread and you'll wind up with, civil war. Well, Brandeis says that's actually not the smart way to go. Instead, we should look at a second approach, which is to use free speech as a safety valve. So he kind of compares conflict in a political community to, like, we might think of like a pressure cooker. Obviously, Brandeis doesn't talk about an Instant Pot because there were not Instant Pots in 1927. But if you've ever used a pressure cooker, you know that they have a safety valve, right, to release the steam and release the pressure. If you didn't have the safety valve open, what would happen? The pressure would continue building. Eventually, your Instant Pot would explode and you'd have chicken tikka masala everywhere and third-degree burns. So Brandeis says that actually the smart way to go is not suppressing dissent, because that's going to have that constant building of tensions until eventually you have an explosion, which looks like, civil war, civil conflict. Instead, we should have free speech as a safety valve. When angry dissenters or disgruntled citizens have the opportunity to engage in free speech, this gives them some place to vent that anger and that frustration that isn't breaking laws, right? That isn't actually engaging in civil disorder, because they always have the opportunity to exercise their free speech rights instead. Now, arguably, in a democracy, this is especially important, right? Because we have majority rule. And that might mean only 51% of the population agrees on something, and that's the policy we go with. But this means we've always got winners and losers, right? And so sometimes your side gets its way, and sometimes it doesn't. So in a democracy, arguably, it is especially important to have these safety valves, because you always have a certain amount of the population that maybe didn't get its way in the last election. All right, so consider what Brandeis says here, right? Do you think that this is a compelling argument? Is the best solution to loathsome or incendiary or even revolutionary speech actually more speech rather than trying to suppress it? What are the potential dangers of allowing more free speech to be the remedy? And also, what are the dangers of trying to suppress like really loathsome expression? So we'll return to this idea when we talk about hate speech, right? So one of the arguments for not having a hate speech exception is that, you can suppress maybe the use of those words in public, but you can't suppress the sentiments. And so if there are laws punishing hate speech, you're still going to have that discontent and anger and discrimination. It just won't have any direction to go in other than, outbursts of violence or disorder. So consider that, whether you think that's a persuasive argument, or maybe whether you think that no longer applies in the 21st century. And so please feel free to post about that on the discussion board. All right, so as I said, they offer a modified version of the clear and present danger test. And this reads, and I quote, "Whether the gravity of the evil, discounted by its improbability, justifies such invasion of free speech as is necessary to avoid the danger." End quote. Fun fact, this is in fact a test that was proposed by Learned Hand. Remember Learned Hand from Masses Publishing Company versus Patton? Well, this case, Dennis, ended up going across Learned Hand's desk while he was in the Court of Appeals. And Learned Hand's recommendation was that they sort of modify the clear and present danger test in this way. So I just want to point to a couple of features of this text that end up being important, right? So, okay, the gravity of the evil. So this is the degree, right? So how serious is the possible disorder resulting from the speech? Second, discounted by its improbability. So we're going to see this echoed later in Brandenburg, right? So one of the prongs of Brandenburg is that the imminent unlawful action has to be likely to occur, right? So this can't sort of give the government carte blanche for suppressing all kinds of speech just because there's the outside possibility that somebody might, interpret it in such a way that leads them to engage in illegal action. All right. So we see Learned Hand laying down in the Federal Circuit more of the seeds that will ultimately grow into the Brandenburg test here. I also want to take a second to talk about some of the key distinctions that the majority opinion makes in the Dennis decision. In previous editions of your textbook, they included Dennis. But for whatever reason, I'm not sure, they have significantly scaled back the First Amendment the First Amendment material in the 10th edition. So I'm going to talk about it a little bit more because of that, because I think it's important, and it just isn't in the textbook. Okay, so in the majority opinion in Dennis, there are a couple of guidelines outlined for what's protected and what's not. So first of all, the majority opinion says that, quote unquote, academic discussion and, quote unquote, peaceful studies and discussions or teaching and advocacy in the realm of ideas, right, are protected. So, and I quote again, "The free discussion of political theories to discuss and evaluate ideas without fear of governmental sanction," end quote, should be protected. So even though the text of the Smith Act seems really unconstitutionally overbroad or vague, the court still wants to carve out space for, for instance, teaching political theory, right? Or discussing different political ideas in an academic setting to be beyond the reach of the government to stop. However, unprotected would be the teaching and advocacy of the overthrow of the government by force and violence, even if that advocacy includes an element of speech, right? So they're trying to draw a very fine distinction here, right? You can sort of talk in the abstract in, quote unquote, the realm of ideas about these revolutionary ideas so long as you aren't actually advocating them. All right, so further important points from Dennis. Majority does talk about the difference between the laws in previous cases like Schenck, in which the government prohibits conduct that might also include a speech element, and the laws in Gitlow, in which the law addresses speech per se, based on a legislative determination that certain kinds of speech in and of themselves constitute a clear and present danger simply for being spoken regardless of the context. So they say that in former cases, the clear and present danger test in Schenck is appropriate because the danger has to be shown in the case at hand. In the latter cases, like in Gitlow, the legislature has already determined that such danger is inherently there within such speech. And so the traditional clear and present danger test doesn't apply, right? So accordingly, the court only needs to determine if such legislative judgment is reasonable, right? So we see them, again, kind of trying to thread this needle between designating that certain kinds of speech are inherently too dangerous to permit, and also saying that context matters, right? So again, the backdrop of this case is the Red Scare. So previously, we had the court kind of hemming and hawing because they were afraid to permit too much free speech during World War I, and now we see them doing the same thing because of the Red Scare. All right, so in the concurrences to Dennis, we see Frankfurter arguing that this is a balancing question, right? So national security versus the right of free speech. So we see him really emphasizing context here. There were dissents, however, right? So there are a couple of important dissents to Dennis. One of them is from Hugo Black, right? So Hugo Black argues that, quote unquote, calmer times will eventually prevail. And he actually, he, in a very polite way, accuses the majority in Dennis of caving into panic, right? Do you think that Black was right? Do you think that, in calmer times, we look back on decisions like Schenck, Debs, and Dennis and think, oh, well, they only decided it this way because they were afraid. If they sort of had all of their wits about them, they would have decided it differently. All right. Douglas also dissents, arguing that, this was just a sort of broad, purposeful organization, but that they didn't have any kind of actual conspiracy that designated future steps that they're going to take, criminal action according to. Okay, so that's all I'm going to say about Dennis. I'm going to touch briefly on a couple of other cases that have important elements. The next one we're going to look at is Yates. So Yates versus US comes up 6 years after Dennis, and we'll see a sort of a development of some of the ideas introduced in Dennis. All right, so Yates, 1957, this dealt with lower level Communist Party members being prosecuted by the government. And so this is kind of a complicated case. So the Supreme Court reverses several of the convictions and upholds others. But the important part of Yates for our purposes is to see that the court further refines the Smith Act, right? So this is the same act that criminalized certain types of expression and association, right, that we saw in Dennis. But so the court kind of narrows the Smith Act to keep it, to try to preserve its constitutionality. As you'll recall when I said that, if a law is found to be facially unconstitutional, there are a couple of different avenues that courts can go in. They can strike the entire law, or they can try to save it by striking certain provisions. And that's what they did in Yates, right? So they narrowed it. So it distinguishes, this was kind of, again, foreshadowed by the parts that were borrowed from Learned Hand in Dennis, but it distinguishes advocacy in the realm of ideas from advocacy or urging action now or in the future. This will ultimately become the imminence part of Brandenburg. 1961, right, a few years later, we see more related cases, right? So I'm not going to go into a lot of detail about these, but in the Scales and Noto cases in 1961, these are companion cases, we see the court revisit the Smith Act yet again, right? And so it refines its interpretation of the membership clauses. And so in order for simple association, right? So these association with others is the core of any criminal syndicalism act, right? Or any act that punishes membership in an organization. So the court refines this further and says that there's a three-part test that has to be met to convict someone under the membership clauses. So number one, the organization the member belongs to has to engage in the kind of advocacy that's described in Yates, right? So that's advocacy or urging of action now or in the future. Number two, the member must have active knowledge of the organization's advocacy, right? And that's sort of borrowing from Whitney back in 1927. And then finally, the specific intent of the group has to be to bring about violent overthrow of the government as speedily as circumstances permit. So we see in the Scales and Noto cases, this test emerging that again is kind of trying to tie the old cases like Whitney and Yates, to present circumstances, but at the same time is leaning more and more heavily on the immediacy of the danger and the likelihood of its occurrence. this finally brings us to Brandenburg versus Ohio, which is the current standard for incitement to illegal action. All right, so the background, by the way, there's a lot of offensive language in the Brandenburg decision because Brandenburg was a leader in his local chapter of the Ku Klux Klan. Okay, so Brandenburg was planning a rally, right, a Klan rally, and contacted a reporter at a Cincinnati news station to cover it. So this was all filmed, right? So there's plenty of evidence of what happened. And in the course of this rally, Brandenburg gets up and makes the kind of speech that you might expect a KKK leader to make, right? And so, he makes reference to how, this is all going to sound very familiar, potentially, how, the white race has been oppressed, right? That, and I quote, "Our president, our Congress, our Supreme Court continues to suppress the white Caucasian race," right? End quote. And he says that unless that stops, there might need to be, and I quote, "revengeance taken," end quote, against, he uses ethnic slur, or like racial and ethnic slurs here, but he refers to Black people and Jewish people, right? And so just as an aside, vengeance is a word, revenge is a word, revengeance, not a word. So as I said, this was recorded, so there's lots of evidence of what he said publicly. And ultimately, Brandenburg was charged and convicted under an Ohio Criminal Syndicalism Act, right? And so this, like these earlier acts we've seen in Whitney and Yates, made it illegal to advocate, and I quote, "crime, sabotage, violence, or unlawful methods of terrorism as a means of accomplishing industrial or political reform," end quote, right? So this is the threat to take, quote unquote, revengeance. Additionally, right, there's an associational part of this, right? Because it is a syndicalism act. And so it also criminalized, and I quote, "associating with any society, group, or assemblage of persons formed to teach or advocate the doctrines of criminal syndicalism," end quote. Okay, so this case goes to the Supreme Court. And now, after all these other cases over all of these years, the court is going to finally come up with a test for what kind of expression advocating illegal action is permissible and what isn't. Now, the law that Brandenburg was charged and convicted under had actually been passed in 1919, right? So way back at the, when we had the Schenck, Debs, et cetera cases. So it was the Ohio Syndicalism Law, passed in 1919, and the purpose of it was explicitly to prevent the spread of unpatriotic views. So the legal question that arises from Brandenburg versus Ohio is, does the Ohio Syndicalism Act violate the First Amendment guarantee of free speech? Right, so this is going to sound very familiar because it's the same question in Dennis and Yates, right, and the Noto case, right? So all of these cases have already sort of raised these questions, but now, it's 1969. Think about the backdrop again, right? The U.S. is in the midst of, these kind of like cultural revolutions. There's a lot of civic unrest. There's a very unpopular war going on, and the court is just a very different court from the one that heard the Dennis case, right? The world is a different world. All right, so ultimately, we get a holding of 8-0 in favor of Brandenburg, right? So the first thing they do, in the opinion, is explicitly overrule Whitney. Now, this is remarkable for a number of reasons. As we saw also in some of the religion cases, the court is very reluctant to come out and say, we are going to overrule a decision that we made in the past. And so this is for a number of reasons. One is that it runs against the principle of stare decisis, right? So stare decisis means literally let the decision stand, right? And this is a principle that the court adheres to, in part to preserve its legitimacy, right? Nobody is going to respect a court that is constantly changing its mind. More practically, the court is supposed to be offering guidance for lower courts. Well, if the court is constantly moving back and forth and reversing its prior decisions, then it's not offering very much guidance, right? It's not predictable enough to offer either legitimacy or guidance. So it's remarkable that the court comes out here and explicitly says that Whitney has been discredited by later decisions based on the principle that the constitutional guarantee of freedom of speech and press do not permit a state to forbid or prescribe advocacy, right, unless it's directed at inciting or producing imminent lawless action, right? So one of the innovations of Brandenburg versus Ohio is that it strikes down this entire category of laws, right? So criminal syndicalism laws, we do not see them in the United States anymore, because laws that punish mere advocacy or association for the purposes of advocacy are ruled unconstitutional here in Brandenburg versus Ohio. We see another important movement, right? So they completely turn away from the approaches that we saw earlier in Schenck, Abrams, Gitlow, and Dennis, and instead of applying maybe that lowest possible level of judicial scrutiny to the question, instead, we see the court applying a very high level of scrutiny, right? Instead of deferring to the government, right, and the government interests, we see the court now showing a high level of deference to expression. All right, so the court says that they cannot support this Ohio law. It punishes people for advocating or teaching violence in accomplishing political reform. They find that the definition of the law is simply unsalvageable, right? There's no attempt to, for instance, distinguish mere advocacy from incitement to lawless, illegal action. So they explicitly overrule Whitney. And in the process of this, they produce a test. So I'm going to talk about the test in the next slide, but just as you're going through the different steps of the test, think about where you've seen all these pieces before. Generally, the court very rarely kind of spins a test out of thin air. There will be something kind of foreshadowing it earlier, right? So remember, you know, in the turn to the lemon test, we saw, for instance, that entanglement piece didn't really appear before Walls, but it also didn't just appear in the lemon test. Similarly, we now see in Brandenburg versus Ohio a test that comes together that kind of, it sort of brings together all of these different ideas that we've seen argued out since the Schenck decision. All right, so there are 3 prongs. All 3 prongs have to be met in order for expression to qualify as unprotected expression because it is incitement to unlawful action. All right, so first, the language of that expression it has to show an intent, right? So an intent to incite lawless action. Sometimes this is phrased directed to, right? The speech has to be directed to or intending to incite lawless action. Second, the danger posed by the speech must be imminent. It has to be something that might happen right now, not just sort of, you know, further down the road in the future. And finally, the danger has to be likely to occur. What does all this mean? Well, again, none of these tests are kind of like perfect formulae for getting or for identifying what is and is not incitement, but I'll talk a little bit about what we might see as examples, right? So first of all, the language of the speech has to show an intent to incite. Okay, what does this mean? Well, remember that the issue with incitement is that the speaker is essentially influencing in a very strong and immediate way others, right? So the audience is the group that's going to engage in the lawless action, right? So, okay, so the speaker has to show some kind of intent to have that effect on their audience. All right, so that's the first part. Okay, directed to generally is interpreted to mean there has to be a very clear target also, right? So it's not enough for me, it wouldn't be incitement for me to go out on Cougar Mall and say, you know, like, we ought not to have classes in Maybank Hall, right? Like, we should, you know, at some point in the future, bulldoze Maybank Hall, right? So that's just me kind of opining. That is not unlawful incitement. If, however, I were to be talking to a class or a mall full of students who are angry, who are tired of stuff not working in Maybank Hall, who had just been sitting in a classroom on the third floor that's hot and barely air conditioned, and say maybe this group of students is angry, right? And maybe also they're holding torches. So if I, at that point, then turn to this group of people and say, you know what, we should go right now over to that building, Maybank Hall, and burn it down, right? And then the students all go, ah, and march over with their torches. That is incitement, right? So it's got all of the elements. So first of all, there's an intent, right? So I specify the lawless action, which is burning down Maybank. There's the direction. I say, this building specifically. The danger posed by the speech has to be imminent, right? I'm saying, let's go do this right now. Not, at some point we should burn down Maybank. And then finally, the danger has to be likely to occur. This is often assessed on the basis of the relationship between the speaker and the audience, right? So if I am talking to a group of people who are hostile to me, right, who love Maybank Hall, right, and that maybe they're throwing tomatoes and bananas at me while I'm urging them to burn down Maybank Hall, that is not likely to occur, right? That group of people is not likely to do the thing that I'm urging them to do. So not incitement. So if a speaker has particular, like authority, right? So in this case, remember Brandenburg was, a leader of this chapter of the KKK. So he had this relationship of authority that meant he probably had some influence. But so yeah, that relationship between the speaker and the audience is important. Also kind of like the state of mind of the audience, right? So people who are kind of indifferent, milling around, maybe taking pictures for Snapchat because they think it's funny, that is different from a crowd that is angry and riled up and likely to go do something. Okay, so I'm going to put up a couple of videos on the discussion board, and you can tell me whether or not you think they pass the incitement test. Just as an aside, we don't see a lot of these cases arise anymore. That said, things always change. We might see more of these in the future. Okay, so the court in this case actually found in Brandenburg's favor. They didn't think that his speech rose to the levels required by the test. There have been a couple of notable cases since Brandenburg where the question was of incitement. I'm just going to take a couple of moments to talk about these. So one of them is Hess versus Indiana, 1974. And in this one, we see an anti-war leader at a protest saying to police, and I quote, "We'll take the fucking street later," end quote. He was arrested, right, so for disturbing the peace. This is often the charge, by the way, is disturbing the peace. It's very broad. And in this case, the court applied the Brandenburg test. And they held that there was no imminent danger, right, because the danger was too far in the future, right? So later, right, or again, doesn't specify a time. This is just advocacy, they said. Okay. Perhaps a more interesting and complicated question comes up in 2010 in Holder versus Humanitarian Law Project, right? So in this case, the court upheld a law that prohibited providing material support to any organization deemed to be a foreign terrorist organization by the Secretary of State. So the plaintiffs in this case argued that the law violated their free speech rights by being too broad, right? Because it applied both to peaceful advocacy and to, and also to providing support to engage in peaceful activities, right? This support wasn't merely for engaging in, acts of terrorism or acts of violence. The court says that they're going to apply a high level of scrutiny, right? So later we'll talk about the levels of scrutiny. We have discussed this also in the realm of freedom of religion. There's an analogous set of, strict scrutiny, intermediate, and rational basis scrutiny in free speech cases. So the court in this case applied strict scrutiny, right? So there has to be a compelling state interest, and the method used by the government has to be necessary to accomplishing that compelling state interest. While doing this, the court said that the law didn't prohibit peaceful advocacy by donor groups, but only prohibited the actual provision of tangible support like money or training, expert advice, right, and speech under the direction or in coordination with a group designated as a terrorist group. The court goes on to argue that such support helps the group, that money given for peaceful purposes is nonetheless fungible, right? So fungible means that a resource can be used for other purposes, right? So this was fungible, or this is a resource that is fungible. So not only does it protect or promote peaceful activities, but also potentially violent activities. So as I said, incitement cases are rare, but they do still come up, right? And obviously we're dealing with different circumstances today than the court was dealing with during, the first Red Scare, the second Red Scare, or, the Vietnam War era. But there's always some kind of political danger lurking in the background, right? So there's always the potential for these cases to come back. But I want to ask the question, what has changed? What are the distinct changes that you see between Schenck and Brandenburg? Take a look at this passage from Schenck and see what there is in common with the test ultimately decided by Brandenburg and what's been abandoned. So just kind of take a moment, think about the evolution of the Brandenburg test and what has really changed. All right, so in the next voice thread, I'm going to talk about expressive conduct, and then we're going to so expressive conduct and time, place, and manner regulations, and then we're going to turn to fighting words.